Hello, everybody, and welcome to. This is the first episode, first podcast of How We Got Here. My name is Jay, along with Paul, the other host. We are going to be taking you through a journey, I guess we can call it, right?
That's right, absolutely.
So, first episode, the show is called How We Got Here. You ever just wake up in the middle of the night and think to yourself, like, how did I get where I'm at today? Like, how did I get here?
Absolutely.
That's I can't be the only one, but I think that's what that applies. That thought process, I guess, it applies so broadly to, I think, just about any topic you can think of, whether it's history. How do we get from the Civil War to where we're at today? How did we get from here to there? I think it applies so broadly. So the whole point of this show and the whole point of this podcast is we take a topic, we explore that topic, kind of starting off with, how it started, and explore that topic all the way through to kind of how we got here today. For our first episode, we thought we might get a little controversial. Just so you know, I'm not going to hold back. I'm going to say whatever the fuck I want. I know Paul's going to say whatever the fuck he wants. But we're here to have fun. We're here to make a topic that may seem initially boring, more fun, more interesting. So today's topic by no means is boring, though. It's a hot topic, highly debated across the board. We're going to be talking about abortion. How it started. How did we go from killing babies to not killing babies to unborn to where we're at today? So, Paul, where would you like to start with this topic?
Well, Jay, when you first started this, I hadn't done any research on this topic at all, and I was really, it's a turbulent topic nowadays, especially with the Roe versus Wade being overturned, and I realized that a lot of some of the controversy that we have today is from the or preconceptions that a lot of people have that this is somewhat of a relatively new topic. And if I talk about relatively new topic, maybe I'm talking 100 years, maybe 150 years. And this isn't just something, when you've seen interviews from some of the people after the Dobbs decision came down, you could tell that they thought, wow, this is a landmark decision. It's really turning new ground. And that's really not the case, and it's not just the uninformed that have been dealing with this as a new thing. There's a priest right now. His name is Dr. Frank Pavone, and Father Pavone has just got himself into a whole bunch of trouble with the Catholic Church. He has been a huge pro-life advocate. I think that he's been. They're not letting him permit to conduct mass at the moment. He put a fetus up on during one of his masses and showed it to the parish, and that's what got him.
Oh my God!
Anyway, but here's the comment that he made. Maybe the reason that so many. Let me read this again. Maybe the reason that so many cannot say a man is a man or a woman is a woman is that for 50 years we've been saying a baby is not a baby.
Oh shit!
So, and obviously he's
that covers
Roe versus Wade, right?
And I think it covers the whole transgender topic as well.
Well, yeah. He's touching all bases right there, and if you look at this in an absence, you'd say, well, this has been something that's been going on since Roe versus Wade, and you wonder what the idea is. So I started digging into the history of abortion, and I was shocked.
And just so everybody knows, when you said Dobbs, you're talking about Dobbs versus Mississippi, the most recent June 2022 Supreme Court decision that gave, I don't want to say, it definitely overturned Roe versus Wade, but that when you say that, I think people think that abortion it's now illegal across the board, and that's not the case. The Supreme Court's job is to is basically just for layman's terms, and you and I are both attorneys, so we're qualified to speak on this. They are only there to decide things on a constitutional basis.
Right.
They're not there to create law. They're there to determine whether something that is being challenged, is it within the Constitution? That's very broad because it could get way deeper than that, because we already know there are rights that are not listed in the Constitution, but are kind of read into. But sorry, so I didn't mean to interrupt, but just so people know, Dobbs is the most recent one. And so you talk about the history. Go ahead.
Well, no, and you brought up a great point, because immediately when the Dobbs decision was announced, you had politicians, you had people in the media, whether it was in print or on TV or on social media, saying that the Supreme Court had banned abortion. Nothing could be further from the truth.
No.
Well, what they had done was they had relied on the provisions of the 10th Amendment and said, this is not a federal rights issue. This is not an enumerated power given to the federal government through the Constitution. And this does not belong on the federal level for a decision-making process. This belongs back to the individual states, where the people of every state can make whatever law they wish in regards to abortion.
So if you want to go to Oregon, or what's another, Washington, right there, they're more Washington State,
New York State.
New York State. Yeah. What this decision did was give the power back to the states, saying this is not something that's on a federal level. The states need to decide this. The people of the states need to decide this. And whether it's abortion or any other type of topic, America, our government, our way of life, our culture was founded on the people have the power, right, and that the federal government should have very limited power. And whether you agree with the abortion decision or not, what this decision does is the Supreme Court saying, listen, this is not a power that we have, that we were meant to have. Mm-hmm. And because of that, we can't adjudicate on it. And unfortunately, it had already been adjudicated on, right, with Roe versus Wade. So yes, they overturned it, but what they did was really fix a mistake that
Absolutely.
was made in the 70s.
Right. And no less than Ruth Bader Ginsburg called it a mistake. You know, she felt it, certainly from the approach that the Supreme Court did, is that they overstepped their bounds when they did Roe versus Wade. And she actually thought it should have been argued under Equal Protection Clause rights rather than the invasion of privacy and privacy rights issues that it was. But, you know, you look back at the history, and I encourage everybody that's listening to this to look at the 10th Amendment of the United States, Constitution, because in that 10th Amendment, it's very clear that any powers that are not specifically and enumerated or not specifically stated in the Constitution to be given to the federal government are reserved for the states. Now, the problem that we've had for 200 years is that federal courts, being creatures of the federal government, have consistently chipped away at the 10th Amendment, chipped away. And in fact, I remember in law school, and I don't know what your experience was in law school, Jay, but I remember my constitutional law teacher telling our class that it was a throwaway provision, that it really was kind of tacked on at the end, really didn't have a ton of application to a lot of law. And that's what we were taught back then. And when you really look into the 10th Amendment, it's not that way. So, so everybody take a look at that, and you'll understand the Dobbs decision, I believe, a little bit better. But getting back to like the history of abortion, and this is what kind of really threw me off. We have laws that go back 3,500 years, going back to ancient Assyria, ancient India, where they are regulating and restricting abortions. I mean, this is something that has been...
There's no coat hangers back then.
There's no coat hangers back then, but, well, we'll get into some of the methods that they used back then, but it was certainly, at 3,500 years ago, this was already an issue. The first recorded evidence of an abortion was in 1550 BC in Egypt. And that's, again, around 3,500 years ago, roughly. So you got to assume that if this became an issue big enough to be regulated 3,500 years ago, then it had to be around for even longer than that.
Yeah.
It had to be a widespread practice. And, that's kind of the things that you run into is that, this may have been 4,000 years old, 5,000 years old. Who knows how long people have been practicing abortion? And then you start realizing, wow, this has been around forever. And then when you get into the history of it, you see that it's really been a controversial issue from day one.
Absolutely, absolutely. And I didn't go back that far, but you did mention earlier the Catholic Church, and there has been, people don't know this, but as far as the Catholic Church goes, there's been some flip flop back and forth between the regulation of it. You've actually, if you read the Dobbs decision, they refer to the Catholics as well as abortion was allowed before the quickening of the child, right? Before the child was quickened.
Right.
And that means basically before the child had a soul. And for anybody who's read Roe versus Wade or the Casey decision or Dobbs, quickening, child has a soul, equals viability. The Catholic Church believes that a child does not have a soul if it does not have the ability to live outside the womb on its own. And you saw that in Roe versus Wade. You saw that mentioned in the Dobbs decision about how that was kind of, it was the practical basis, not the legal basis, but the practical basis for the whole viability rule within Roe versus Wade. There seemed to be a lot of focus on that too. In Roe versus Wade, it sounded like, or it felt like, the Supreme Court was really just trying to split the baby here. Before viability, okay. After viability, not allowed unless the mother's going to die or something like that.
And it's interesting you bring up the quickening thing because and the timing of that, because some different societies use different kind of standards. You had this concept of quickening, which was basically meant when the mother felt first stirring of the baby in her stomach. And then you had ensoulment, which could be quickening, but could not also be quickening depending on the culture that we're talking about. And then they got into, even some of the cultures got into when the fetus was formed. And you go back through the Christian church, you go through different cultures, all the Abrahamic religions. If a child was aborted, or if a fetus was aborted prior to the quickening, that was not an abortion. So the Abrahamic religions kind of said anything before a quickening or ensoulment, it's fine. You're not aborting a baby. Everything afterwards, you are aborting a baby. So therefore, everything before is okay. Everything after is not okay.
Yeah.
And that's kind of, when you start getting into all this stuff, and then you go into the Orthodox Christians, they've got a different timing. Aristotle talks about ensoulment and that the boys were ensouled after 40 days. Females were ensouled after 90 days. The early church actually adopted that because the Romans basically adopted a lot of the Greek traditions. And then when the Roman Empire became Christianized, they just brought that right over. And so you had this whole thing going on, but then the Orthodox Christians were saying 21 days. The Judaism had a split where some people were saying then the soul was there at conception, and other ones were saying that the soul was there at birth only, and that abortion right up to birth was permitted. So, I mean, you had this Hinduism with reincarnation said conception, and the soul went in at the moment of conception because that's when the soul was reincarnated into the fetus.
So no abortion ever.
No abortion
You're
ever.
killing a baby at that point.
Absolutely. And it's crazy when you go through all the different cultures. I mean, abortion's been with us since the day one, but it was practiced in Japan, China. The Aborigines in Australia practiced abortion. The Native Americans in North America practiced abortion. The Native Americans in South and Central America practiced abortion. I mean, literally everywhere in the world, abortion's been practiced.
Yeah.
And since day one.
So I think also what we're talking about here is there's been a lot of regulation on abortion prior to Roe v. Wade. thousands of years of regulation. Most of it was concerning making it illegal on a broad basis, trying to take abortion out of the picture, no matter what. And then up until Roe v. Wade, I believe about 3/4 of the states had laws banning abortion. And so that would make 25%, had some type of law regulation that would allow it. So now we get to Roe v. Wade, right? So what I find interesting about that is the plaintiff in that, the woman who's pregnant, just wanted to kill baby, just wanted to have an abortion, right? She just wanted to have an abortion.
Yeah.
Took it to, some lawyer who challenged in the Supreme Court.
And she's got a kind of controversial past, doesn't she? Yeah.
Oh wow!
Yeah.
So I mean that topic, it brings up that even brings up even more, because she's taunted and she's flaunted as some type of political being who took a huge step for women's rights, and that was by accident. I mean, by the time in Roe versus Wade, by the time she'd already given up 2 of her babies for adoption.
Yeah. And
she's like, you know what? I'm tired of giving these babies up. I want to fucking just get them out of me and not have to worry about it. So that's also, and I know, everybody just instinctively should know, challenging a law on a constitutional basis federally isn't done in 9 months or less. Right?
Oh, very rare.
So she couldn't have the abortion, so she had to have the baby. And that was her 3rd baby, gave it up for adoption. Now, what I find funny is this if you read the Roe versus Wade, or even the Dobbs, they mentioned in Dobbs too, is they try to challenge it and say that this woman didn't have standing. And just standing means like you no longer have a reason to go to court. For example, if my neighbor plants a tree in my yard and I sue him, and then after I sue him, he removes the tree, then it's a moot point, and I no longer have standing to sue him because he's fixed the situation. It's similar to this. So I just thought this was a funny argument, going, it doesn't matter anymore. She already had the baby.
Right.
She doesn't have standing. That's a dumb argument to make, because this was bigger than that. Whether you were for pro or anti-abort, pro-life, pro-choice, whatever the hell you want to call it, this was bigger than that. If you won every argument as, well, she already had the baby, she can't have standing, then there would have been no way to challenge it whatsoever. So what was her name? Norma McCorvey.
Norma McCorvey.
Yeah.
Yeah, and what's quite honestly almost sad about her situation, she was used as a political pawn, because her attorneys were looking for that case where they could challenge Texas's abortion law at the time. And she just happened to walk through the front door. She wanted an abortion. She wasn't out to set, to change the United States. And as you mentioned, the checkered past, this was her 3rd child. She had been involved in prostitution. She had been involved, with drug addiction, a lot of other issues along in her life. And
she tried to capitalize on this.
She tried, but she realized that she was being exploited by the people that were in favor of liberalizing abortion laws, and she jumped ship and actually became a pro-life advocate.
Yeah,
and then realized she was being exploited by them. In fact, she was homosexual, and they demanded that she renounce her homosexuality. And that's when she jumped ship from them. And it's kind of you feel she had a checkered life, but she was a political pawn.
Absolutely. Yeah. It's sad that she was used that way. And just to be clear, and it is sad for her on her end that she was exploited that, but she also exploited the child as well. Shelley Lynn Thornton, that was the child in this whole Roe versus Wade. That was the child that she wanted to have exit her body. Let's call it that. And that's another thing. So that's where you get that story from Thornton is McCorvey would call her daughter and say, I'm being used for publicity. Now, what's interesting is that Shelley Lynn, she's given up for adoption, has a great family, great person. From all accounts, seems like a model citizen of society. But never actually met her mom, like publicly. Like she spoke to her
I
mom,
didn't know that.
but never actually like physically met her mother. But she did say that her mom told her, McCorvey told her mom told her that she wished she did get the abortion. Could you imagine that? Your mom says, I wish I was able to have you, to just not have you as a child.
That's heartbreaking.
That is.
Yeah.
That is heartbreaking. So let's talk then about, we talked about the 10th Amendment not being kind of, that's what Dobbs used to, let's say, overturn it. But what did Roe versus Wade use to make this constitutional? Because I promise you can read the Constitution and you won't see the word women have the right to abortion. You won't see that. And while you're looking that up, you mentioned earlier the Equal Protection Clause.
Right.
That RBG. Now, what that is for the listeners, in a very broad term, is that there's no legislation allowed that inherently or purposely or even accidentally kind of alienates one sex, race, and other. For this purpose, we'll talk about sex, so male versus female. Now, I think why they couldn't use Equal Protection Clause is because that legislation didn't like alienate women from men. Only women are able to have kids. Only women are able to get an abortion. So it wasn't a legislation that kind of separated the two. It was just happened to be that way because men can't get pregnant. And my God, I couldn't imagine having to push a baby out.
Well, what Ruth Bader Ginsburg really, and she's a fascinating jurist, but when you really think about what she was trying to do and what she was trying to say, she felt like the court went for it all in Roe versus Wade, and she felt they overstepped and that they went too far. She felt like the Equal Protection Clause, with the right case, would have provided better, would have withstood attack much better than the Roe case did.
The 14th Amendment.
Yeah.
There's the first, the fifth, the ninth, but the 14th Amendment is really what Roe versus Wade was decided on.
And, one of the things that, and she brought up a really good point too, she felt that Roe versus Wade almost guaranteed the physician's right to conduct an abortion more than it did protect a woman's right to get an abortion.
And why is that?
Well, because of the way of the phrasing. I mean, she literally, what she had said about that was that Roe was not about women's choice, but that it was about a physician's right to practice medicine. And she just felt the emphasis wasn't where it needed to be in that case. So she had a lot of problems with Roe versus Wade. And obviously the judicial legislation from the bench was one of those criticisms that she had also.
But also, let's be clear. I mean, Ruth Bader Ginsburg was, let's call it pro-choice, right?
Yes, she was.
Right.
Absolutely.
So a pro-choice woman, very clearly had issues with the way Roe v. Wade was decided.
Yeah, she didn't like the process.
And keep in mind, too, like at that time, most of the justices are male. The attorneys who brought the case were male. This was very much not about women's rights. It was a political move in Roe v. Wade. There was a lot of push publicly for women's rights, and because this was in the 70s.
73, I think it was.
Right, 73. So there was just, during that time, there was a huge push for women's rights, and rightfully so. I mean, just in general, I've never been a woman. I've got a pretty small wiener, but not enough to classify me as a woman. so I can't really speak to women's, their suffering and what they've been through. But if they felt that they were being marginalized, and by all accounts they were, I mean, they didn't have the right to vote up to a certain point. I mean, up to a certain point, they were considered, couldn't own land. So they obviously were being marginalized. But I think that kind of was really the fire starter here for this political move.
Well, and the history, you used the word that women were being marginalized, and their whole experience with abortion in the United States has been one of marginalization, and it's kind of fascinating, really, when you think about it, because up until 1840 in the United States, abortion was widespread, and it really didn't have a negative stigma to it. And the people that began to bring a negative stigma to abortion itself was the male physicians in the United States. And this, what they did was just callous, but it was also about market share, because up until that point in time, midwives were obviously women. Many women healers were used throughout the United States. And of course, midwives, yes, they did abortions, but they also did the pregnancy care. They did, the delivery. They did the postnatal, the post-delivery care of the mother, all this kind of stuff. That was a big market. You were talking about an era of big families. You're talking about a lot of money being made, and the physicians were locked out of that field. And
the male physicians. And all physicians were male at that point.
Exactly.
Yeah.
All physicians were male. And
it's the same people who,
and the midwives were obviously
they'd put leeches on you if you had some type of, the fever.
So they're looking at this group of people that have a huge chunk of the healthcare field, and so they formed the American Medical Association was formed in 1847, and one of the things that they started doing was they advocated to the states, saying, "Hey, we know more about reproductive practices than these midwives." They should not be practicing in this area, which was not true, by the way.
Oh yeah, they had dicks. They did It's just funny to me.
Yeah.
Hey, you know what? I know more about having a baby than the people who have the babies.
Yeah,
that
argument doesn't really fly, does it?
No, what a great sales pitch you had to have.
But these guys were so successful that by the time the 1900s rolled around, basically all the states had banned abortion and had rendered midwives and female healers obsolete. I mean, it was, they probably were more successful than they could have ever hoped to be. And so that's what drove abortion underground for decades. And, and that's where you get a lot of the leading up to Roe and how we ended up getting to Roe. How did we get here?
Yeah, marketing. That's how we got there. Yeah. I think, what, as we progress through this, I think we're going to see that a lot of the changes in America, let's call it just America in general, are going to be due to some type of ploy that involves money on some level. Mm-hmm. Marijuana, criminalized mostly due to race back then, but and we won't get too deep into that because we're talking about abortion today, but it all revolved around money. I mean, it seems like everything just revolves around money. And that's just funny to me. I like money, but it can turn nice men into greedy men, and greedy men become evil men.
Well, and I think one of the things that I really found fascinating was how widespread abortion was up until even in the 1860s. For every 4 live births that there was one abortion. And when you think about that, that is a stunning percentage. You would never, ever, ever have thought that you would have 1 out of 5 pregnancies ending in an abortion, which they were doing that in the 1850s and 1860s. And that already had been a societal shift because say in the 1700s, the majority of women that were getting abortions were unmarried women because, the stigma of being not married and having a child was very strong back in the 1700s, say. But by 1850, the majority of women that were getting abortions were married women. Yeah, and then you got the use of abortifacients, which is fascinating in and of itself because, like we were talking about, abortion going back 3,500 years, 4,000 years, whatever. All these cultures, the term abortus means miscarriage in Latin, and facients means making. So what abortifacients were herbal remedies that enabled people to induce a miscarriage. And these things were being used all the way up until the 1900s.
Well, let's talk about that. You mentioned some of the processes from 3,500 years ago. Like I said, I made the joke that there weren't coat hangers back in, 3,500 years ago. So what were they doing 3,500 years ago?
So, well, and unfortunately, you're not as far off with the coat hangers as you might think, but certainly abortifacients were really, really important, and that was all pre-quickening, pre-ensoulment or whatever.
Before they had a soul.
Yeah, right. And so what they would use were at every culture, the Aborigines, the Babylonians, there's cuneiform tablets that have prescriptions on how to make these elixirs or herbal concoctions to induce miscarriages. The Native Americans had them. The Asians had them. Everybody had them.
So basically poisoning the baby.
Yeah, and inducing a miscarriage. But some of the more cruder methods.
How dangerous was that on the mom?
Actually, if it was done in the pre-quickening, by all accounts, it would appear to have been relatively safe.
Oh.
Okay. But there were other methods that weren't so safe. They would take extremely hot baths. They would drink gin. They would put girdles on their abdomens and squeeze them really tight. They would do very high exertional exercise. Sometimes they would, take a strike or a blow to the abdomen. I mean, and they use blunt tools and they use some sharp tools.
That's the most fucked up thing I think I've ever heard of.
Yeah. If you got your head on straight, it's shocking to even consider that. Well, and these chances have been getting take for thousands of years. And what's crazy? There was an island in Greece, and they grew this plant called Silphium. It's called an island itself. I think it's Cyrene or Cyrene. Their sole export was this drug, and it was known, this plant, and it was a powerful abortifacient. I mean, this is how widespread the use of this stuff. Abortions have been going on and on and on and on, and it kind of going back to what I talked about early on, where people have this misconception that this is a recent argument. Man, this has been going on forever and ever.
It's a recent argument within the United States.
Yes.
But even then, I mean, this isn't a topic that just happened, didn't just start.
Oh no.
It didn't just start. And a lot of our law today, just in general, a lot of your state's laws, a lot of your federal is built on canon law. It's built on King's Court, Old English law. And so, of course, there's going to be abortion laws on the books because back in the King's Court, there were abortion laws on the book. So let's talk then just about Roe v. Wade was really decided on the 14th Amendment. There was other mentions, the first, the 9th, the 5th.
And I think the 4th too.
And the 4th as well. And, everybody knows the 5th. I plead the 5th. But really, Roe v. Wade turned on the 14th Amendment and the due process. Just paraphrasing here that the 14th Amendment is rather lengthy, but just paraphrasing, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without the due process of law. That's the portion of the 14th Amendment that Roe v. Wade really, really turned on. Roe v. Wade mentions privacy. I promise you, read the entire Constitution. The word privacy is not in the Constitution. The word abortion definitely isn't in the Constitution. So, what just in general, what the Supreme Court has to do on these cases where they're being challenged on a constitutional basis, but like the 10th Amendment is specifically enumerated in the Constitution. And if it's not specifically enumerated, then what the Supreme Court has to do is that right inferred somewhere in the Constitution? Is there some mention of it that we can get to from point A to point B, right? So Roe v. Wade turned on the liberty and privacy as well, because a lot of privacy laws constitutionally comes from the 14th Amendment as well. And that the liberty portion of that, the depriving them of liberty without due process of law, and that straight banning abortion deprived them of that 14th Amendment. Now, we kind of already let the cat out of the bag in the beginning that we're not saying we're pro-choice. We're not saying we're pro-life. We're just saying from a legal standpoint, constitutionally, Dobbs got it right. But why did Roe get it wrong on the 14th Amendment?
Well, I think what you had this massive movement that had started in the 20s and 30s. Margaret Sanger opened up her first clinics in the 20s and 30s. So you had this groundswell. The clergy began, were fighting on the other side. So you've got this debate raging, and of course you've also got the underground industry that may or may not have been, a disaster for some pregnant women, and there's some statistics that suggest that it wasn't quite as bad as what we've been led to believe. But be that as it may, in the 50s and 60s, you certainly had a groundswell in favor of legalizing or liberalizing the abortion laws throughout the country. And Colorado and California, I believe, 1967, so that was 6 years before Roe. That's when they started legalizing, or liberalizing abortion. Now, interestingly enough, California thought by when they liberalized in 1967, they thought, well, the number of abortions that we're going to do are not going to go up. The first year it was legal, I think there was 5,018 abortions that were conducted in California. Within just a few years, it was over 100,000 a year. So, you got your unintended consequences too that came from Roe versus Wade, and that fuel the whole pro-life, argument that we've been now debating for the last 50 years.
Or just lies. I mean, just marketing. Oh, we're not going to see abortions go up after this. It's not going to happen. Don't worry about it.
It's been done in a lot of things, right? Like, when they projected Medicare expenses, they said, it'll never go above, was it like $24 billion? And now we're in hundreds of billions of dollars.
Oh, yeah. It's just, it's what I do to my wife all the time. When she is worried about something, it's going to be okay. It'll be fine. Don't worry about it. But in my head, I'm going, oh, we're pretty fucked, But it's say what you need to say to keep them at bay, and kind of kick the can down the road and deal with it later,
Well, and so now you've got the Dobbs decision out there, and again, I think you and I just try to emphasize as much to the people who are listening out there that it did not outlaw abortion. I mean, there have been so many myths now promulgated about Dobbs and what it has done. It did not undo the right to privacy. This is another thing that's been said now. And of course, Judge Thomas, in his concurring opinion, it raised some issues about the Equal Protection Clause and substantive due process, and people just lost their minds.
Oh yeah,
about his
there was a
comments.
lot of focus on that.
Yeah, 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 and people are pointing out that well, what he's saying is that people, because there's interracial marriage is one of the issues that immediately someone brought up, and I'm thinking to myself, well, wait a minute, Judge Thomas is involved in an interracial marriage.
Mm-hmm.
Why would he be bringing up? Why would he, of all people, be talking about those kind of marriages not being recognized by the states or by the federal government? But you're seeing a lot of misinformation out there. Really, 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 it's kind of amazing. Quite honestly, you turn on the TV and
now most of it is because this decision largely, from a political standpoint, largely affects the Democratic, party and the more liberal folks. A lot of the misinformation has come from that side because that's who it's affected negatively. That's not a political statement. That's just saying, for example, with gun laws, that's more Republican, more conservative. So you're going to see misinformation from them as well on anything that would be negatively impacting them, whether it's, states regulating or the federal government regulating how many rounds you can buy, things like that. But so a lot of misinformation. I mean, a lot. It's not banned. And keep in mind, too, that because the right to privacy is not specifically enumerated in the Constitution, then the scrutiny that the Supreme Court has to look at when deciding whether some type of law is constitutional or not, and let's say we're using the privacy aspect of it, there's different levels to this as far as scrutiny goes. If it's something that's specifically enumerated, then it's strict scrutiny, and the state has to show like absolute compelling reasons why this is constitutional. For things that are not enumerated, it's more like a rational basis. Does the state have any rational argument as to why this law is constitutional or meets the rational basis requirement? And it's just rational. They have to have some legitimate state interest. That type of scrutiny or that type of review is reserved for specific laws not enumerated in the Constitution. So that's very, very important to remember and to think about when we're talking about abortion. Because as I've stated so many times, you won't see the word abortion in the Constitution. So the level of review that the Supreme Court has to look at it is not at the highest level of review. It's more on a legitimate basis, legitimate interest. And one of the factors to determine whether this is a legitimate review is the history. Is this something that's embedded in our history? And in the 70s, about three quarters of the states had laws out, banning abortion, outlawing it, and only about 25%. So it's not something that's deeply rooted in our history. But as you mentioned earlier, that is because there had been kind of this big push from the male physicians to kind of get that stigma going from the 1840s and on going into the 60s and 70s, and they were quite successful. So do you think, right, had these physicians back then not been successful in kind of getting the states to outlaw abortion, and let's say going into 1973, it was the reverse. 25% outlawed it. 3/4 had, regulations saying abortion was okay. I think personally the Supreme Court then can say, yes, this is deeply rooted in our nation's history, allowing these things to happen. But that's just not how it was.
No, and the 14th Amendment's kind of been an abused amendment. I mean, it's been kind of used for a lot of different purposes. I mean, one of the initial uses for it was Plessy versus Ferguson, which permitted separate but equal which was effectively legalized segregation in the United States. Yeah, and so again, you've got an amendment that the court on multiple occasions has used it to infer rights that are not spelled out. Subsequent to that, you had Brown versus Board of Education, which basically reversed Plessy versus Ferguson and said, no, separate facilities are not inherently equal.
Well,
you know.
I think because the factual matter of it was they weren't equal.
Right.
I think that what Brown versus Board of Education was really focusing on was, okay, you're saying your basis, because it's not specifically enumerated, your basis for this is saying this, we have a legitimate state interest to segregate these two races, whites and blacks, and we're separating them, but they're equal. So therefore nobody is harmed. But when reviewing it, when actually reviewing the equal part of it, the Supreme Court said, wait a minute, yes, it's separate, but your education for the African Americans, for the black community is worse. Your facilities are worse. It's not equal.
I can't even imagine anybody in a Plessy versus Ferguson era thought that it would be separate and equal, you know?
Well, it goes back to what we talked about earlier about how, when the whole abortions aren't going to go up. It's going to be, we're not going to see an increase in abortions, and we see 5,000, 100,000 within a year. It's the same thing. They're going, oh, no. Plessy versus Ferguson, like, no, it's fine. They're equal. Yeah. They're treated the same. I know we enslaved them and we treated them like shit, but I promise you, cross my heart, hope to die, stick a needle in my eye. This time we're serious about it. It's equal, I promise. It kills me. And the 14th Amendment, the reason why we have to look at the Constitution the way that we do is because it was written so long ago. It was written so long ago. It's been amended several times, at least 14. It's been, obviously, this is a dumb joke, but hey. It's because they can't, in no way could our forefathers or anybody really have thought that you and I'd be sitting right here with microphones talking about this shit hundreds of years later. So it does we do have to interpret things into kind of what we're at today, but that's where the abuse comes in. That's where the abuse of that power comes in, of interpreting it really and kind of bending it to how you see fit as the Supreme Court justice there.
Whether, do we want a breathing, living constitution, which is kind of the term that we always learned in law school, right? One that kind of adapts to the times, but maintains its character? Or are we going to be constitutionalists and originalists? And we're seeing this argument play out now. I mean, it is, and I don't think we're done seeing this argument play out. I think that the Dobbs decision is probably the first major shot across the bow. But I think the court that's in place now is going to attempt, possibly, to return some powers to the states that was taken from them that probably shouldn't have been taken from them.
Where it should be. It should be. I mean,
it should be.
Across the board, not just with abortion. And if you live in a state, if you live in Texas and they outlaw abortion, fucking move. This isn't, I know that people, it's my home. Okay, but one of the great things about the United States is that I can move from Texas to Florida, from Florida to Ohio freely and establish citizenship within that state because I am a citizen of the United States of America. It wasn't always like that prior to the Constitution. I mean, Florida had different currency than Texas, right? So
it's a compact of sovereign states.
Yeah, exactly. So it's not like we live in covered wagons and it takes 6 months to go 100 miles. It's fucking easy to move. So this is not just about abortion. If you live in a state, you don't like their views and you feel very strongly about it, fucking move. That's just the bottom line.
Don't even really have to move. Maybe just drive a few hours.
Yeah, because go somewhere else. You can still, if you feel that strong that you should have the right to abortion, and I'm not saying you don't have the right to abortion. I'm just saying the federal government doesn't have the right to regulate that. If you feel you have the right to an abortion, go somewhere that allows it. If you feel that you should be able to buy an AR-15 without, well, unless in an AR-15, if you feel you should be able to buy, some type of gun without a strong background check, move to a state that has, minimal laws. If you feel you should be able to open carry your firearm and you live in a state where you're not allowed to do that, well, if you feel strongly about it, go somewhere that allows it. So that appeals to my gun-toting friends out there across the pond.
Well, and so we're left with the Dobbs decision, and I just saw this poll the other day. So there's a poll that's conducted by Harvard, and American Center for American Political Studies, and the Harris poll, and no one can, I don't think, can accuse those of being right-wing pro-life organizations.
Very well, I think they can very much the opposite.
Exactly. And this poll basically found that 72% of the respondents, and this runs across Democrats in terms of majorities, Republicans in terms of majorities, independents in terms of majorities, 72 women, men, 72% of the respondents felt that there should be restrictions on abortion after 15 weeks.
Well, viability is not until 19.
Well, think about quickening. We have come full circle here. I mean, we have not changed our mindset one bit in a couple thousand years.
No.
I mean, this is what's kind of remarkable about this whole argument. We have spent so much blood, sweat, and tears, so much money, so much emotion. People have gotten so upset about this, and the people feel the same way about this now as they did 2,000 years ago.
So ain't shit changed.
No, and it's a remarkable testament to when you think to yourself, why aren't our lawmakers just like listening to what the people are saying rather than trying to tell us what we should be thinking?
Yeah.
But I mean, literally, you go through history, and if you're talking about a quickening at 18 weeks or at 21 weeks, or you're talking ensoulment, which is usually a few weeks before that, typically 14 weeks, maybe a little bit less than that, 12 weeks. We're right where people are right now in terms of where they think the cutoff line should be in terms of when abortions should not be happening again, in terms of at least the vast majority.
So that's funny. I mean, it's not funny. I don't know why I said it's funny. You're right. And you're going to see that across the board, especially with just different people are going to feel the way they feel no matter what. And we're not here to tell you how you should feel. We're not here to tell you that abortion is wrong or that abortion is right. We're here to tell you the fucking facts.
Yeah.
This is how it fucking is. You have no idea if I'm pro-choice or pro-life. I have no idea if you're pro-choice or pro-life, and we can keep it that way. And it doesn't fucking matter to me. Because what matters to me, personally, is I don't want a government, federal government, to be Big Brother. We spilled some fucking tea in a harbor because of Big Brother.
That's right.
I don't want that shit to happen. So when I saw the Dobbs decision come through, and as much as I saw it hurt, like actually emotionally hurt a lot of my friends because they felt that we took a big step back.
Yeah, mine too. Yeah.
And I didn't want to see them in pain. So I kept my views out of it because when I saw the decision come through, I was happy. And not happy because abortion is banned, and I'm using air quotes. I know you can't see me, but because it's not banned, but because we got it right.
Yeah.
We got it right. the Supreme Court is there to decide constitutional issues only. And abortion is not a constitutional issue.
And Roe versus Wade was a horrific example of judicial legislation. And what that basically means is, for the people out there that aren't familiar with that term, is that courts, their function, their design is to interpret law, to look at precedent, past law, how it applies to the present situation, and looking at the law on the books, whether it's a statute or a regulation of any sort, and applying the facts of a case to the law as it stands. What you had with Roe, especially with their 3-trimester partition and the various qualifications they put on all that, that didn't exist in any law anywhere. They literally made that up.
Yeah.
And said, this is our new law. And that is not what our courts do.
It's our, and not just the Supreme Court, any court of the land. Imagine you are a criminal. You got arrested for carrying an ounce of marijuana on you, and you go in front of the judge, and the judge just goes, well, it's only a misdemeanor according to our current law if you're holding an ounce or less. But you know what? I think this should be a felony. And therefore, I'm going to try this as a felony case.
Yeah.
And now you went from a ticket to fucking possibly years in jail because some judge decided they didn't like what was going on and made a new law. It's the exact same thing on a smaller scale, but it still affects that person. This affected the nation as a whole.
Yes.
And it gave the Supreme Court more power than they should have had.
Oh, definitely did that. It made the Supreme Court something that it was not before Roe versus Wade. But it also essentially wiped clear all the abortion laws in the United States and said, we're starting from scratch. This is the new law. And if you got anything that contradicts what this new law is, it is now illegal, which again was one of Ruth Bader Ginsburg's big criticisms of all this was that she actually preferred, and she said this in multiple interviews, that this issue be resolved at the state level. It should be resolved through the people's representatives. It should be resolved through legislature. It should not have been resolved through this court.
Absolutely not. And so that also, one thing we haven't really touched on is the Casey case from 1992. Because you mentioned the 3 trimesters.
Yeah.
The Casey case from 1992 actually overturned that portion of it. Right. But even the justices in the Casey case basically said, in layman's terms, there really is no judicial basis for why Roe versus Wade is what it is. But due to stare decisis, which means let it stand.
Right.
The courts in the Casey case were too concerned with how it would look politically, essentially, to do the right thing. So they kind of towed the line because they said, well, we really have no legal basis or no basis for why Roe versus Wade was decided the way it is, but it's the system that we have in place that we must stand by the precedent and let it stand, except for I think they went from 3 trimesters to 19 weeks is what I think Casey went to. Is they went to more viability, went to anything 19 weeks or before you could abort, anything after the states, not that you couldn't abort, but that the states could regulate. Keep that in mind too, because even in Roe versus Wade, it was up to this point you can, up past that point
you can with some
you
restrictions.
Can with the restrictions. And Casey was like, after 19 weeks, it's state's decision. Because you had some states that were allowing to abort well past viability.
Still do.
Yeah, well past.
Well, I guess we'll have to see about that now.
Yeah, we'll have to see. So we're about an hour into the conversation. What else? What else do you have? Anything more you have to say about this topic?
It just, again, the whole thing has been so fascinating to me, just to kind of get back into this. And I ran across these numbers on what that Harris poll, the Harvard poll talks about. And it found that 55% of those surveyed opposed SCOTUS, the Supreme Court overturning Roe. But only 25% of those people believe the high court should have the authority to set abortion standards. I mean, it's like a total contradiction in terms. It's like, yeah, we agree with, we wanted Roe to stay, but we don't think that a court should be has the authority to set abortion standards, which is exactly what Roe did. So I mean, it's part of hopefully what we're going to get done here over the next episodes and times when we get together and talk about different subjects, is we can help educate and bring some of these issues to light with people, and help people understand some of the issues that are really out there today. And again, how did we get here?
But what's going to happen, right?
What's that?
Some motherfuckers are just going to be like, "Fuck you, you piece of shit! Yeah, I should be able to kill my baby whenever I want." Great, you should go somewhere where you can. Okay, because that's what this is about. This has nothing to do with whether or not you should or should not be able to.
And I think people too need to realize, I know Kentucky had a sunset law that went into effect that had pretty draconian abortion laws, and it's been.
Why use those big words, Paul?
I'm sorry, but they, there's been an injunction that's been set down to prevent it from going into effect. And for the people out there that are concerned, I think you're going to see a lot of compromise on this issue. It's only the extremes on both sides that want the most draconian type of results, and the majority of the country's in the middle. And so I think we're going to get it right, but we're going to get it right the right way, as you had been talking about.
Yeah.
It's going to be done through the people's representatives and their state legislatures.
Yeah. So if you're out there and you have to understand that while I know it's very tough to believe and very tough to see this, but the only way to really incorporate change within your state, if you don't want to fucking move and you want to stay, that's fine. You'll need to either live with what's going on or take a stand to make that change. Start a foundation. Reach out to your state representatives. The only way that you're going to change your state's laws is to change the person that's your representative. Keep that. It seems like people have forgotten that. The people that we vote into the Senate, into the House, into Congress, as a whole, they're there to represent us as their citizens. They're supposed to do our bidding. Now, they're not, because of the whole lobby situation and everything, but...
Yeah, not even close.
But they still have to be voted in. So if you really and you really feel strongly, and this is not just about abortion, just about any of your state's laws, because marijuana is another hot topic as well, and different, guns are a hot topic as well. So if you really feel strong about these topics, then work to change them. Run for office if you feel the need to. Get a following. Get out there. Make your voice heard. Don't resort to violence, because that's not really going to do anything for you.
Right.
But if the person that represents you in your state is no longer representing you in your state, then get them the fuck out of office.
Yep. Absolutely.
Bottom line. So, Paul, first episode down.
Sounds good.
I think
it was fun.
I think we've got it. Hey, was it a little rough? Yeah, but I had fun. Did you have fun?
I did. It was a lot of fun.
I hope out there, whoever's listening, enjoys. Stay tuned. We've got some more exciting topics coming up. Hopefully, have some guests in the future, because this isn't just going to be about politics, and this is going to be about just the law. Don't think of that, because the question of how we got here is so broad. You talked about, we talked about in the past about, bringing on nutritionists or physicists or different people to talk about just general talk.
Sports figures, interesting people.
Interesting people, sports figures, like football. How do we get from A to B? How do we get from fucking leather helmets to CTE, right? So
yeah,
sit back, enjoy. I'll set up an email too if you want to email us. Send your questions, thoughts, comments. I know we're going to get some hate on this one, that's for sure. But it's how we got here, jp@gmail.com. That's HOWWEGOTHEREJP@gmail.com. Thank you. See you next time.